Mabuhay! In this legal aspect in tourism and hospitality, we are going to talk about civil law. But before that, let me introduce the topics. On the first part, we are going to know what is civil law all about. Next is the obligations and contracts, the partnership, and the general law and property. Of course, civil law has a relation on tourism industry, and that is what we're going to know or to talk about later on. Now, let's talk about what is civil law. Civil law are part of the legal system that deals with people relationship, property, and business agreement. Civil law possesses a sustainable tourism for the country, hence, it helps in promoting and providing a safe space to tourists and indigenous people residing in some tourist destinations. There is a law that protects our indigenous people, which is the Republic Act H317 or the Indigenous Peoples' Rights Act. It is an act to recognize, protect, and promote the rights of indigenous communities or indigenous people. The example for this is Apo Wangol, she is the last Mambatok of Kalinga, who is also known as the oldest tattoo artist in the world.
So now, let's discuss the obligations and contracts. So what is obligations and contracts? It is the responsibility that parties to contracts are required to bear upon entering into legally binding agreements. There are four elements of an obligation. First is the passive subject, or also called debtor or obligor. The person who is bound to the fulfillment of the obligation, or he was a duty. Second is active subject, or also called creditor or oblig, the person who is entitled to demand a fulfillment of the obligation, he who has a right. Third is object or prestation, or also called subject matter of the obligation, the conduct required to be observed by the debtor. It may consist in giving, doing, or not doing. Without the prestation, there is nothing to perform in bilateral obligations. The parties are reciprocally debtors and creditors. Last one is juridical or legal tie, or the vinculum, or also called efficient cause, that which binds or connects the parties to the obligation. The tie in an obligation can easily be determined by knowing the source of the obligation. It is that which binds parties to the obligation. It is otherwise known as the efficient cause. Next is nature and effect of obligation. First is obligation to do. If a person obliged to do something fails to do it, the same shall be executed at his cost. Next is obligation not to do. When the obligation consists in not doing and the obligor does what has been forbidden him, it shall be undone at his expense. Third is obligation to deliver. The obligor may bind himself to deliver either a specific or generic thing, civil obligation and natural obligation. When we talk about civil obligations, it is based on a positive law and gives right of action to compel their performance, while natural obligation is based on natural law but on equity and moral justice. Hence, it is not enforceable by court action, but after voluntary performance of the debtor, he can no longer recover what he has given. Next topic is contract. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render service. There are three elements of contract which are essential elements. It is the requisites of a contract. Natural elements are those that be presumed to exist in certain contracts unless the contrary is expressly stipulated by the parties, like warranty against hidden defects in the contract sale. Third is accidental elements. It is the particular clauses, terms, or conditions established by the parties in their contract, like interest and penalties. There are three stages of contract. First is preparation, conception, or generation. Second is perfection or birth. Third is consummation or termination. There are also three characteristics of contracts: obligatory force of contracts, autonomy of contracts, and mutuality of contracts. That is all for obligations and contracts.
Mabuhay! I'm student number 24, and let's talk about partnership. A partnership is a form of business where two or more people share ownership, as well as the responsibility for managing the company and the income or the losses of the business generates. The purpose of partnership or partnership contract is to establish a business enterprises through a legally binding contract between two or more individuals or other legal entities. According to Article 1769 in determining whether a partnership exists, these rules shall apply. First, except as provided by Article 1825, persons who are not partners as to each other are not partners as to third person. Second, co-ownership or co-possession does not of itself establish a partnership, whether such co-workers or co-possessors do or do not share any profits made by the use of the property. Third, the sharing of gross returns does not of itself establish a partnership, whether or not the person sharing them have a joint or common rights of interest in any property which the returns are derived. The receipt by a person of a share of the profit of a business is primary evidence that he is a partner in that business, but no such interferes shall drawn if such profits were received in payment. According to Article 1770, a partnership must have a lawful object or purpose, and must be established for the common benefit or interest of the partners. When unlawful partnership is dissolved by judicial decree, so the profits shall be confiscated in favor of state, without the prejudice to the provisions of the Penal Code governing the confiscation of the instrument and effects of a crime.
Mabuhay! I'm going to discuss Presidential Decree number 1083. This topic concerns the system of the Filipino Muslim laws covering marriage and divorce in the Philippines. Divorce is not generally permitted in the Philippines under the Family Code. However, it is permitted in restricted circumstance under the PD 1083, also known as a declare to ordain and promulgate a code recognizing the system of Filipino Muslim laws, codifying Muslim personal laws, and providing for administration and other purposes. Article 14, Nature. Ang nature ng marriage is not only a civil contract, but a social institution. Its nature as the consequences and incidents are governed by this code. In the Sharia, and not subjective to stipulation, except that the marriage settlements may to a certain extent fix the property, the relation of the spouses. Before, during, or after the celebration of the marriage, if the amount or the value thereof has not been fixed, a proper dower marmiatil shall upon the petition of the wife be determined by the court according to the social standing of the parties. Next is Article 21, Payment of dower. Subject to the stipulation of the parties, the dower may be fully or partially paid before, during, or after the marriage. The property or estate of the husband shall be liable for the unpaid dower or any part thereof. Section 3, Marriage. Article 27, by a husband, the rule of Islamic law permitting a Muslim to have more than one wife, but one wife unless he can deal with them with equal companionship and just treatment as enjoined by Islamic law, and only in exceptional cases. Article 28, by widow. No widow shall contract a subsequent marriage unless she has observed an Ida of 4 months and 10 days, counted from the date of the death of her husband. If at the time the widow is pregnant, she may remarry within a reasonable time after delivery. In such case, she shall produce the corresponding debt. The Philippines naman, Muslim holidays may also be officially observed in other provinces and cities. That's it. I hope you learned something from this lesson. As a Filipino, it is important to learn about our rights, especially the civil code, because it is concerned us. Choose UE, choose tourism.
Private ownership. Article 421. Patrimonial property means a property owned by state and not intended for public use or public service. Example is yung mga friar lands, commercial buildings, and it can also be acquired by private individuals or corporations through prescription. Pasok dito yung sole proprietorships, general partnerships, limited liability companies, non-profit organizations, and corporations. Article 422. Property of public dominion. Public dominion means owned by state. When no longer intended for public use or for public service, shall form part of the patrimonial property of the state. Article 423. Sinasabi dito na ibang mga properties sa provinces, cities, municipalities Hindi lahat accessible for public use or for public service since ang ibang mga parte nito ay patrimonial property.
Ownership in general.
Article 427. It is a general right of a person to control a thing, particularly in his enjoyment, possession, disposition, and recovery. Article 428. It is about the right to enjoy. It also includes the right to possess and the rights to use. The rights to dispose is the right to consume, destroy, or abuse, or the right to alienate. If I own the house, I can use it, live in it, receive tenants, destroy it, sell or mortgage or donate it, and recover it from anyone who has deprived me of its rightful possession.